Dear guests and distinguished participants, welcome and thank you for joining the second edition of Paperless Court webinar series. My name is David Mkirchan. I'm e-Justice Development Manager with Synergy International Systems. Today's webinar will be the continuation of the one we did in December last year, where we talked about applications of digital tools to court operations, such as filing the cases, summoning to the court, and online hearings, collaboration on cases by court personnel, judgments, and reporting. Video of that webinar is available on our YouTube channel. This time, we will be exploring how some of these activities can be optimized even further by using advanced tools such as OCR, optical character recognition, automatic voice-to-text transcription, online document editing within the system, and much more. In order to do this effectively, we will follow the logical steps of case management. A litigant will file a case, registry will receive the case and process it with all necessary compliance checks and pass it on to the judge to perform their duties. To demonstrate all of this, I'm joined by my colleagues, Mrs. Naisan Karunji, an e-justice expert at Synergy International Systems, and Mr. Khachatur Matevosyan, Vice President of e-Justice at Synergy. For your information, all participants, except for speakers, will be muted during the webinar, but we encourage you to submit your questions via chat. We will dedicate 15 minutes to Q&A session at the end of our webinar. French language translation is going to be available by selecting French from the interpretation menu at the bottom of your Zoom window and muting original English. Before diving into the main discussion, let me quickly give you an introduction of Synergy and what we have done so far in the e-justice domain. For that, let me just quickly share my screen with you. I hope you can already see that. So Synergy has been operating from its 5 offices around the world. Our headquarters is in Washington, D.C. We have offices in Armenia, Netherlands, Rwanda, and Ukraine. Our 350 plus employees have worked in more than 80 countries for different information system implementation and consulting projects. On this map, you can see the highlighted names of the countries where Synergy has been engaged in projects specifically related to justice institutions. This year, 2 of our recent projects have been launched and are being actively used by our customers. One of them is ECMIS, Electronic Court Case Management Information System for the Judiciary of Uganda, that was launched in March 2022. And the other one is Integrated Electronic Case Management System for the Judiciary of Zimbabwe, launched in May 2022. In parallel to these launches, which we are extremely proud of, we have expanded our geography and signed 4 new contracts since we met last time in December, namely Integrated Case Management Information System and Electronic Records Management System for the Federal Court of Ethiopia, Jail Management System for the Department of Correctional Services of Jamaica, development and implementation of the Forensic Case Management System for Moldova, and development of integrated office management system for the Office of the Representative of the Republic of Armenia before the European Court of Human Rights. Now, let's move on to the topics of the webinar and start with the filing process and some of the major pain points for litigants and public users when they are coming to the court for the first time. Naisan, what are the expectations of litigants in this process of filing the cases and evidence to the court?
Thank you, David, and thank you everyone for joining us. The expectations of litigants is convenience. Litigants need to be able to file their cases and evidences in the shortest time possible. If we look at a litigant that wants to file a case in the Supreme Court, they have huge loads of case documents and evidences. And this in the physical or the paper-based system is complicated. It could take hours and days even, depending on how far the court is from the person, for them to be able to file such a case or such case documents. But also, when we look at the e-filing systems coming up, the lawyers are still suffering by uploading each file at a time, and this takes a lot of time. It takes hours for them to be able to upload cases. If they're filing in Supreme Court, they have hundreds of evidences and hundreds of case documents. So this could take a very long time for them to file cases, and it's not convenient for them. Number two, some laws and regulations require that litigants sign some case documents before they can file them to court. For example, pleadings, affidavits, and many others. So what is happening now is that litigants prepare these files in the Word applications or other applications. Then they have to print, sign, scan, and then attach back into these systems. All this is time consuming and it is not convenient for the litigants. Another thing I can talk about is when we look at international litigants, they want to be able to access their courts without limitations, geographical limitations, or any other kind of limitations. Obviously, this was complicated in the physical environment because they need to board a plane, go to another country, file their case, and if they want to follow up their cases, they have to do the same. But even in the current circumstances where some courts are adopting e-filing systems, it becomes hard, especially when it comes to payment, because most of the systems do not support online payments. So they have to at least know someone in this country where they want to file the case so they can help pay for them case fees. Or they have to go through the long processes of bank transfers in international banks to be able to pay court fees. All these processes are tiresome and inconveniencing for the litigants. So it would be good if the litigants are able to access their justice in the convenience of their homes or offices and be able to do all the process of filing from the start through payment to the end without any limitations. Thank you, David.
Thank you, Nathan. Now I want to pass the same situation to Khachatur, who can showcase what proper e-filing looks like as an answer to these major challenges and issues, and what the main components are for that. Please, Khachatur.
Thank you, David. Actually, I will show one of our demo applications where we will see how litigants can use the system. Actually, litigants can register through the application to get access to the system. And if they have already the account, through the username and password, they can log in into the system, where they can see all the cases that they have already filed to the court, and also the cases which are yet dropped, so they have started but not yet submitted. So this is an example of an interface for a litigant where they can see the items which are pending action from their end, notifications, they can have calendar, which can show the hearings or the sessions that they need to participate to. And also they can access not only the cases which are currently in draft or pending their actions, or they can also access all the cases that they are participating in. Now, if we take an example where the litigant, which is Vivian Williams, has already created a case, but not yet submitted to the court, so we can open one. And the case itself indicates that it is yet a draft and it is pending submission to the court. Now, if we edit the case to fill some core information to make it complete and submit to the court, we'll show a couple of examples. So one of the things is that when you start with electronic case management system in any country, usually whenever you file an appeal case, and this is an example of a civil appeal, you need to link the previous order or some documents from the case which is being appealed. For systems which are already piloted for several years, all the cases and information are there. So it's just about linking and searching. But for the new start, if we want to link a reference or originating case and you cannot find in the system, you need to create. And this is just an example for creating such one. For example, appealing a case from the commercial court. And let's say this is the first appeal. Now, we may have one document to upload, but sometimes you can have, as nice and tall, hundreds of documents. So one thing which becomes handy is about uploading multiple files at the same time. So let's say we have 4 documents. We can just select 4 of them and upload them all together, like making a bulk upload. So this way, all the documents will be uploaded and it will make the life of the litigant or of the lawyer much easier. Now the case has the reference. Then we have the case parties, myself and the respondent, my lawyer, and we have an application. So one thing that we noticed in many countries, it creates hassle when litigants has every time to download the file to view what he or she has uploaded. But here it's much easier. So there is an embedded previewer of a file. This is a scanned document. And if there is a need to sign the document electronically, the litigant can click on sign. And if they have a mouse pad, they can just put their signature and sign the document. Whenever the document is signed electronically, system automatically signs it digitally. So the file will be signed and electronically and digitally. And when all the information is complete, the litigant can just save the file and submit it to the court. And whenever the court receives the file and make the compliance check and creates a payment order, litigant will be notified and can make the payment online. So this is just about a click to send the case to the court, where the corresponding court staff will be notified and litigant will be aware that now the case is submitted to the court. And after it's submitted to the court, litigant can have access to the case, but not modify it. Whatever relates to payments, so the payments can be inside the case. So litigants can assign the payment specific to the given case. But if the litigant has access to multiple cases, the payments, all the payments which will be pending for the litigant will be in one place. So here shows all the payments that litigants currently is pending to pay. And to facilitate the payment process, payment can be done offline and litigant can upload the payment receipt, or through integration with different payment platforms, make the payment online. So just an example, this is an example of integration with Stripe. Just to fill the card number. This is test, so we can skip all the other steps. And when the payment is done, automatically the status of the payment will be changed and the court will be notified about the payment performed. So this way, no matter if the payment is for a stamp fee or filing or any document requested, the payments can be done and automatically the status of the payment will be changed, which will notify and the court and the other related case participants. David?
Thank you, Khachatur. We saw what the essential elements are when submitting cases to the court in this part, and the logical next step in this process is when the case is processed by the court registry. Registry happens to be the first stage where these piles of documents are collected and screened, while others from the court are prepared, signed, stamped, and sent out. So let's do the following. I'd like to ask Nysen to take us through the average day of a court registrar and their needs in performing these duties. Please, Nysen.
Thank you, David. Registrars are an interface between the court and the litigants. On one hand, they receive information and documents from the litigants, and on the other hand, they share information and documents from the court. Now, registrars in different jurisdictions may have extra other activities that they need to perform. But in general, one of the main activities that the registrars do when they receive documents from the litigants is checking their compliance to the laws and regulations to make sure that they are admissible in court, they are within the competence of the court, and the court would be ready to hear them. The second duty of the registrars is to ensure communication with the litigants, timely communication with the litigants, such that litigants keep track of the statuses of the cases, the progress of the cases. And this, in the paper-based environment, you can imagine, was complicated or is complicated for some people who are still in the paper-based environment. Any communication has to be physical or where possible through mobile phones to call them. But even then, no one can actually keep track of these communications or even keep evidence that there was such kind of communications. One of the most important duties of the litigants, of the registrars, is to summon the litigants, to prepare summons and letters of notices, sign them, stamp them, and send them. In most cases, the hearings may be adjourned because the litigants were not summoned on time, or they were not summoned properly as speculated by the laws. So this is very important, that the registrars would notify or summon the litigants in a proper manner. What this involves now is that the registrars prepare these files, these documents, the summons, they print them, they sign them, then they send them via email or via other processes. But even then, David, it is hard to keep track or to know whether these emails have been delivered or not. And most importantly, it's hard to keep these in the evidences of the case. So if a litigant comes into the hearing and says, I did not receive that email, it is very hard for the registrar to pull up an evidence from that case and show that this summon was actually delivered with the email that they sent.
Thank you, Nyson. Khachatu, let's take a look at the system and the functionalities allowing registrars to carry out these daily activities in a much more efficient and speedy way. I noticed that we have many registrars in our participants, so I think this is going to be very insightful for them. Please.
Thank you, David. Now I will log in into the system as a registrar of the court and will explain how it actually works. So the first thing, the login page is the same. However, based on the permissions of the user, the interface and the access levels are totally different based on the role of the user. Now, where we have logged in as a registrar, the system automatically gathers the information where registrar has something to do, and registrar of the court has access to much more workspaces than the public. Plus, when we submitted the case to the court, now the system automatically created the notification. So registrars can be aware of what is happening inside the case and inside each component of the case itself. But for easier access, registrars can concentrate not only on the cases or applications or sessions, they can also see which are the ones which are exactly overdue. And this gives possibility to facilitate and reduce the time on the case. Meaning, system automatically, based on the court rules, define the deadlines and prompts the users. Now, registrars can easily access the cases which are yet open or closed or pending. And we will now access a case which is pending filing heads of argument. When the registrar opens the case, so they can see the overview and they can access any part of the case and also see the flow that it has actually passed. Now, as Nyson told, one of the important things for them is to be able to easily check all the documents. So we can see some of the documents which are available here and also access all the documents of the case. System automatically gathers all the documents and makes it easier for the registrar to access all of them. Plus, for the notifications, system has embedded notification tracker, which gives possibility to the registrar to see which are actually the different notifications submitted to the parties or to the court staff, and also to see the ones which have been sent or delivered or undelivered by different reasons. Now, one of the things that registrar usually do, they can need to create a letter, for example, to the parties. For example, we will now try to create letter for calling heads of argument. Let's say today, we want to notify one of the parties, for example, Vivian, and subject of the letter generated automatically to file the heads of arguments. Now we can just save it as a draft, but to facilitate the process, this can be just saved and signed at the same time. System automatically generates the document, the official letter with corresponding letterheads. And again, the registrar can put a personal signature or a stamp. For example, here we can put a signature. And if I have my signature saved as a registrar, it will appear automatically. As well, in some jurisdictions, there is also need to put a stamp on a document. So we can have the stamp. And upload the stamp. And if there is a need also to add the date on a stamp, now our document has an electronic stamp and electronic signature on it. One of the things is that sometimes in many countries, the electronic signature is not enough. And it is sometimes required to have also documents signed not only electronically, but virtually. But by experience, not all countries actually have possibilities or does not have the corresponding infrastructures and the digital certificates. To facilitate it from electronic systems perspective, anytime a signature or a stamp is put on any document, system automatically signs it through a digital certificate so that this can be validated. So if we download the letter, and this is just an example of the letter, so it's signed electronically and stamped electronically. If we open the same file with any PDF reader, we can see that the signature and the stamp are also validated by digital certificates. So, which means that if somebody tries just to put a picture, it will not have the certificate. And if any single letter or part of these documents signed or stamped electronically through the system will be tried to be changed, the document will show and these certificates will notify. And this captures all the timestamps and the user who actually signed. So this makes the electronic signature and stamping much more secure. Now, the registrar has created a letter, and there are two possibilities: to submit it electronically, which will automatically create an email and submit the files, or to submit it physically. Sometimes there may be a need that the litigant doesn't have an email or is not available or has requested to be notified physically, to submit it physically. Then what happens? We may have multiple documents inside the case, like the one that we just created or any others. And sometimes there is a need to share some of the documents through email. The classic way was that the documents had to be downloaded, then uploaded into a link to an email and sent. But to make it easier through the system, the registrars have possibility to select the file or files and send it, share it with the court staff, or automatically with the parties who have emails, or other recipients. And when this is sent, automatically this is being captured in the audit of the notifications, so that the other court users will be aware that these documents have been submitted. And if they are not delivered for any reasons, the failed delivery report will be available in the case. So no matter if these were system-generated notifications or emails submitted, system will capture them in the notification audit. And also, like we demonstrated last times, there are many other features available for the registrars, like the collaboration tools for the chat, the calendar for them, and many other features. However, for the sake of time, I will pass the file to David. David?
Thanks, Vlachadur. This looks great. Next is one of the hot topics in the judiciaries, and the one I am really excited about the most. It's the online hearings and conducting them via different digital tools. Nyson, how important is it today, especially after COVID, and what are the main challenges judiciaries face when it comes to digital tools, specifically for hearings?
David, I think that COVID-19 has made it clear that the courts need to leverage technology and that courts can actually be offered as a service. So with that, many courts are venturing into online hearings, and it has vast advantages, but I'm just going to mention a few. And one of the best advantages, I said before, is convenience. Everyone needs convenience. And it's amazing that with online hearings, you can have hearings in the comfort of your home or office, irrespective of your physical location. Whether you're in the same country or not, you can still conduct your hearings. Another advantage of online hearings is the security part of it, is that when prisoners are being transported, for example, from prison cells to courts, there are instances where they may attempt to escape, or some of them may even escape, or their transportation buses may have a technical issue that would either delay or adjourn hearings. And so with the online hearings, it makes it easy for litigants to conduct hearings in the confinement of their prisons or cells, and be able to communicate to the judges their needs, and they would be catered for. The other advantage that I would like to talk about with the online hearings is that the mediation has also been made easy with the online hearings. If we talk about civil cases, we have witnessed mediation between siblings or even people in the same case in different locations who are able to sit at the same table with the judges and complete their cases without even ever going through the process of hearing. So with that, the courts have ventured into either purchasing physical video conferencing facilities or using the available applications, video conferencing applications like Skype or Zoom to be able to cover this need. So some of the challenges that are being observed here is the need for integration. When the video conferencing facilities are not embedded within the case management system, then there has to be a process of integration to make sure that the online hearing facilities and the case management systems can talk seamlessly. When this is not possible, it creates some kind of inconvenience that the judges have to work in one system, and when it comes to online hearing, they use another system. What this brings to play is the issues that I'm going to talk about, like the issue of recording. How do we keep the recordings of the online hearings? This means that most times the recordings of the online hearings are kept in a separate location, while the case management system keeps another part of documents, of case documents. So it creates inconveniences for judges to go to one location to look for the recordings and go to another location to write the judgments. Another challenge that has so far been complicated is the transcription as well. is that when these recordings are given out, there is no clear way of transcription in most cases. This means that the registrars or the clerks are tasked with writing the hearing minutes for each hearing. And even then, it's hard to keep them in the same location as the case file. Or the transcription, when there's no transcription and the registrars are writing the minutes, most of the important information may be lost in between. So the judges have a hard task of going back and looking for the recordings, reading them, and also reading the minutes and trying to put everything together for them to come up with an informed decision. Thank you, David.
That's very insightful, Mason. So now let's go to Synergy eCase, where Hachatur can demonstrate us how these issues are handled in the system. We will also do a quick online hearing for everybody to see that in action. Just a quick reminder for our participants, please don't forget to raise your questions in the chat. We're monitoring it and we'll get back to them at the end of the webinar. Please, Hachatur, go.
Thank you, David. Again, to schedule a hearing, I will log in as a registrar and explain how it works. So technically, to make it easier to organize virtual hearings, what we have done, we have made it possible and integrated the platform with the video conferencing tool. So when the registrar wants to schedule a session, and this can be either a physical or a virtual, so it's the same flow. Now, if we open the case, the one that we were working on, and we go into the sessions, when we create, let's say, a hearing, let's say we schedule it today, for example, for 15 and the time. Now there are two possibilities. Whenever we click is online, system automatically connects to the virtual conferencing tool, creates a session, and sends the link to the participants, which would be the case parties, and the core staff, which is required to participate. And we can select the judges or the bench members or the assistants. And if they have any other hearings scheduled through the show availability, we can see that. Also, in some countries, there is a need to make the hearing public. So if it's public, system has also possibility to integrate with YouTube channel and make the transition in YouTube live. Now, when this is done, automatically after the session is complete, it will come to the virtual court part and both the recording and the chat will be available. Now, to show how actually this works, we will open one of the hearings in the calendar. Now, this one, which is scheduled and we're 3 minutes late for it, and my colleagues will also join. We can just open any of the already hearings and click to start the hearing. Now, when I join the hearing, this is the virtual hearing, which gives possibility to see and automatically get from the case the information. So automatically the judge, and the interface is customized. We have the judge, the registrar, the appellant, respondent, and other court staff. And whenever hovering, system automatically shows who is who. Now we'll make a small demonstration. So my colleagues will speak and we'll see how the recording actually works. Judge?
Today, the Supreme Court calls case with the parties Vivian Williams and John Anderson to breach of contract for hearing. Vivian Williams, state your full name, please. I don't see your lawyer. Are you going to wait for him or are you going to represent yourself today?
My lawyer has a family emergency so I will represent myself in today's hearing.
Do you have any additional information or evidence you would like to add on your case?
No, Your Honor. I have submitted all evidence and information I have to the system.
Thank you. We will adjourn now and resume again in 4 hours. Court is adjourned.
Now, we will leave the court session as everyone left. And we'll go back to our system. So one of the issues that this way is being resolved is that judges or the registrars or the parties, when they have access to the system, they don't need to either connect to different networks or use different solution or have some other specific tools installed or used. They can just use their browser and the web camera, either the camera embedded on the notebooks or some outside cameras, and use it. Now, if we open the case that we were just looking, in the session part, for this specific hearing, system will automatically gather the data of the conference. So this is it. And the judge or the user who has access to the given session, they can download the recording and they can extract also the transcription. So when they click extract, automatically it starts extracting and doing the voice to text from the recording of it. And if need be, also the recording can be downloaded. And as soon the extracting is done, it will appear as a text file, which can be shared with the team of doing the transcription, or the judge can have access to it online. Sometimes there is a need to make the transcription and then fine tune it. But the good thing, there is no need to go through different softwares to connect to different networks to handle all it. So when it's extracted, it's just the possibility to download, and the text that my colleagues were reading, we can see it here. This text can be shared with the transcription team or kept as is in the system. David?
Thank you, Khachatur, and thank you, colleagues, for joining our virtual hearing. I'm sure our participants found that very useful. Now, let's talk about judges and what their work looks like. We know that decision-making is at the center of judges' work. However, as experience shows, judges have to go through quite a few challenges to reach the point of making judgments. Nyson, please help us understand this better with real-life situations and examples from what you have seen in courts.
Thank you, David. To make informed decisions, judges need access to case documents and precedent and also related laws. When information is scattered in different places, it becomes tedious for judges to make decisions. So one of the main requirements that judges need is to be able to consolidate different parts of the document or different documents into one file and be able to read that file at once. And also be able to jump from one page to another without any distractions. In real life, judges have a life. Sometimes they may need to travel, or sometimes they may be in places where there's no internet. So it is important for them to have access to their case documents and also be able to read their case documents in their convenience. The judges also require quick access to precedent. They need to be able to search the precedent and search parts of cases, even the scanned copies of case files. Most of the courts have adopted technology recently, which means that they have a long archive of physical files. Most of these files are scanned and attached into the systems, or they are attached into other storage areas. But what judges actually need is to be able to search through these documents, even if they are scanned, and be able to access precedent and see what different judges said about the issue they have. And with this, they can search with keywords to be able to see what was said about this issue so that they can make informed decisions. David, when the judges have come to a decision, they want to be able to easily and securely edit their judgments, write their judgments, store versions of their judgments, go back to them, proofread them. And when all that is said and done, they want to easily sign the documents and share them in a timely manner.
Thank you. I think many judges, and especially judges that are participant to our webinar today, can relate to all those problems and issues. So let us now observe how Khachatur tackles each of these concerns in Synergy e-case.
Thank you, David. Now, I will log in as a judge into the same system. And again, one thing to note is that now for the judges, we have also pending several orders and the cases which are pending for their action. But what I would like to raise here is one thing that NICE told, to be able to search the precedents and information. Now, not every time the documents that are being uploaded by the public are actually readable ones. Sometimes they can be scan files. So scanned and looking like a picture and not the letters itself. Now, as for the judge, we have opened the system by a judge, and we have a document which is actually a scanned file, so it's just a picture. Now here comes in handy the OCR, which gives possibility. So every time any document is uploaded, automatically system captures all the words from it through the embedded OCR tool. And when this is done through all the files and cases, when it's done this way, then the documents can be searched online. So as for a judge, if he or she wants to search any information which can be coming from any of the files attached to a case or group of cases, or even decisions pronounced, there is a way to search by keywords, for example, contract. If they want to find a precedent having a contract, system will automatically bring all the files in all different cases where it is available. And also having the additional filtering tools, a specific type of documents can be selected. So if there is a need to search in the orders or search in summons or affidavit or any other forms, the judge can do. And from here, they can actually download the files they found or even preview them. And even for the scanned application, using the embedded OCR, system automatically captures the content of the files and makes them searchable for the judges. Now, if we go back to the case, the information of the case is actually available. So the judge can see the general one or in the originating case, or can go to any section of the case file. But sometimes it's nicely told, for some judges, there has been the preference to work on the files, let's say, offline or remotely. So one of the things which comes in handy, if the system has multiple attachments, more than 12, for example, attachments, the judge, one of the things is that can easily merge all the documents together and make one PDF file with the hyperlink. So if the judge wants, selecting all the files, selecting the order that the judge wants, and click on merge documents. System creates this way a new PDF file with list of files paginated correctly altogether, so they can work offline. Another option that judges prefer and do is when they want to export all the documents and to have all the copies together. So exporting, this is an example of exporting, let's say, the full case, where already not only the readable files like Word files or PDF files can be exported, this can export all the files all together. Now, another thing that my colleague Tyson actually noted, besides searching precedents or searching information, not only the files, but actually inside the contents of the files, there is also ways to work on the Word files themselves. Now, when let's say we have a draft order, so the judge started writing the judgment, and this is an example of the order, and on a Word file, but inside the system. This one is actually a Word file uploaded into the system where the judge is right. But to work on the file, it's not mandatory to download, work on the Word file, and then re-upload. There is a way to edit the file through the embedded online editor. So meaning if the judge is working on a computer or from outside where he or she has no access to internet, or let's say that does not have access to the Word, via Microsoft Word on the laptop, he or she can do it through the embedded tool. Whenever the information is being saved, system also keeps track of all the modifications. So for every file in the system, there is the history of the file. So the judge can see how he was progressing, what he was writing actually. And also, if judge wants to remember something, can open the compare and see all the newly added or changed items. And in the end, when judge completes the order, he can sign it electronically. Now, when the judge signs the document, so the Word document, the system automatically changes the file and makes it a PDF, signed PDF document. This way, also, if there is no need to have a separate Microsoft Word or Adobe PDF, the system does everything on the backend, and when the judgment is signed, so it becomes a signed PDF already. And this is the option one. The option two is that the judge can write all the order details in the system. But for the transition period where judges prefer to work on Word files, they can use the embedded editors, have the file in the system, edit it online, and then upon signing, make it a PDF document automatically like we did. David?
These truly have the potential to transform courts and how judges work, Khachatur. I also remember that one of the main struggles that paper-based systems and judiciaries that depend on them is that they cannot overcome the issue of reporting and analytics. So judiciaries are interested in tracking and analyzing data in real time rather than waiting till the end of the year report or the quarterly report. What would you propose for this situation, Khachatur?
Thank you, David. Actually, in the system, now I will log in as a user who has much bigger permissions. And system has embedded analytical tools and reports and also report builders. So if I open one of the reports, this is just an example of a report of the data that we have in the testing system. So we have possibility to filter the information to see number of pending cases or the backlog cases, pending payments, sessions, closure tendencies per court or per category of the case, currently open cases. And if we want to reduce, we can just deselect and filter just on the go to see the payments and if need be, also to drill down. Drill downing means this is, let's say, a system level information, which we can filter easily. And if we want to drill down from analytics, we can just drill down, for example, from payments amount, like we have 20,000 pending payments in the courts. We can drill down to specific parts of the system, for example, to a specific report where we can already see the exact payments. And if need be, we can just open any of the payments directly from analytics and start working on it, and also check by the due date and follow up with the parties. So if they have paid or not. But all these visualizations is actually one part of the system. The main advantage is that these reports are configurable dynamically and not requiring development effort. So if the user has permission, they can just click on add and add new type of reports, charts, graphs into it, and even change the reports which are currently in place. So here, the same report can be made by different other criteria and other items. For example, if I change it to case category, it will change, and so on. Now, this is the analytical part, and supporting tabular reports, graphic reports, chart reports, and online reports, which are updated based on the data field, makes the life of analytics much easier. David?
Thank you. I'm certain many of our participants will take a note of this as well. And since we have some time on our hands, let's briefly discuss the configurability of the system we're working with. We get this feedback a lot. How do we make sure that after implementation, courts and their IT personnel can maintain and change the system if need be? Because usually when case management systems are implemented and changes or even small modifications are required, judiciaries either depend on the vendor or their in-house IT teams to code, test, and deploy them. This forces judiciaries to keep skilled programmers and DevOps engineers, which is quite a financial burden, to be fair. Khachatur, please elaborate on this. Let's see how the most common aspects of court operations can be configured on the go by the administrators of the system.
Thank you, David. Actually, it's very important to consider that though those type of systems built in courts or any other justice agencies, they are built according to the country's regulations and standards, though those regulations are not fixed like the court rules, they can change. Now, system in the last 10 years, we have embedded so-called the different builders, which give possibility to configure the system. Now, as an example, whenever there is a need to add a new field or a new form in the system, before this would require a database developer who would create it in the database, after an application developer who would create it, update something in the source code, and then update the overall release. But with the possibility of new technologies, for example, if we open the case, so all the information that we were looking on, all the fields that we were seeing, they are here. For me to add a field in the database, I can just click on create a new field, select the type of the field I want, and automatically it will be created in the database, and it will give possibility to do it in the main case itself. So all the user interface can be configured. For example, the forms, the main case form that we were looking, this is the one where we had the court, the case category, and all the other components. It's just a drag and drop to change them, to classify them, and to modify or to add anything inside here. So this way, whenever there is a need, this can change. In the same way, system is embedded with the process management and business process automation tools. So the processes, let's say, can be drafted through a business process builder, and also the rules can be made configurable So whenever there is any rule or any process and the calendars, this can be customized in the system. And also system supports the automation engine embedded in it, which creates a sort of automation. For example, whenever a case is assigned, if there should be any condition or transition or notification, this is all being customized. And of course, the same relates to the permissions, where all the organizational chart, the users' roles, the policies can be configured. And most importantly, whatever done in the system is being tracked, detailed in the audit of it. So if any navigation, any click, any modification, any attempt is being captured by the system, so that those system has multiple, let's say, modules or configuration functionalities. Any single change in it is being tracked, and not only modifications relating to the data, but also every single click in it. So this makes it in a way that even if the system has a lot of information and multiple security layers embedded, this will give a possibility to track who is doing what, or who is trying to access where, or what has been done. So detailed audit of every single action and event is being captured in the audit module of the system. And also the policies which are defined, which gives possibility to manage the policies and the permissions. And also at the level of each field, for example, if we open any of the role, like the role of the assigned judge to the case, so whatever the judge was seeing, starting from the banner, the navigations, the portfolios, so all this is configured and permission driven. And the same way for the security, the data actually the judge has access to, for each single field, it's possible to define the exact permissions. And I think, David, we are reaching the 1 hour that we promised. So if you don't have anything to add, I think we can pass to the question Q&A session. Thank you.
Yes, absolutely. Thank you for that, and thank you for the detailed explanation on the configurability part. Now let's go to the questions our participants have asked. And now, please note that for those questions that will not be answered today, we will get back to you individually via email. And the first question that I want to ask, and I want Pachatur to help me with that, refers to the security aspect in general. So what are the elements that the security of Synergy eCase is based on? And we have a very specific question as well. Are judges allowed to use their own devices and connect to the system, or are they restricted to using devices provided by the court?
Thank you, David. Actually, the platform which we're demonstrating has passed different security certification, and our company itself has the ISO certificates and also is compliant to GDPR. Whatever relates to the specific devices used in the court, the system is secure in a way that it also supports the two-factor authentication and integration with the Active Directory, plus all the information which is going through the secure channels, so allows the judges to use even their mobile phones to access the case in a secure way. So in some countries, we also implemented systems where for logging in, it's required to have digital certificates for a specific type of users. In other places, there is separation for the two-factor authentication. And we have also systems for totally closed outside of internet. So system supports all options in a secure way. And usually by experience in countries where we implement like systems, it depends on the current regulation. Currently, the same platform and system is implemented in more than 10 countries. And the number of countries starting using the Synergy eCase is increasing. And yet we didn't have any security breach. And even in the systems which are widely used by the public and by the judges, and having no restrictions on the device or on the network that they use.
Thank you. Thank you for that. I hope that answers the question. And my second question is going to be about the transcription. We have two questions here, and I want to group them together. And the first one is it possible to have transcripts from audio if the court session was public and streamed on YouTube and not online? And the second is, was the transcript generated from a computerized system, or was it done by a person manually?
Thank you, David, for the question. Actually, we have integrated the system with a transcription engine. It's a voice-to-text library. So which automatically takes the recording, which is being uploaded into the system, and makes the transcription. So technically, it is possible to upload the transcript, to upload the video recording and get it. But what we have done, so we did the virtual session, the system automatically started recording it, and after the recording was ready, automatically the transcription was done.
Thank you. Thank you for that as well. We have another question, again, very broad one, and I want you to answer to this one as well. One of our participants is asking, is this a specialized software with all the features discussed and that which can be used as it is by any court anywhere in the world?
Thank you. Actually, the system is configurable, and by experience, as we have covered multiple jurisdictions, we have implementations in United States, in Latin America, in African countries, in Pacific, also in Eastern Europe. So system can be configured to any regulation, and this configuration can be further dynamic, so that if any change, these changes can be implemented. System itself can be taken and used theoretically. However, light adjustment to the current processes or the import of current laws would be important to be considered. However, by experience, as the system has most of the features or majority of the features required for courts or justice sector institutions, its customization, it's more adapting some processes and forms to the current regulations.
Thank you. Let's answer one more question and we will wrap up here. And again, I will repeat, we will get back to the questions individually via email, so please bear with us. The last question is, how does the court deal with all paper-based cases? And this is basically speaking about going from paper-based systems to the paperless court.
Nice. Could you help me with that, with the question based on your experience?
Yeah, thanks, Khachatur and David. So when moving from a paper-based system to a paperless system, there are two possibilities. And we have experienced this in the different courts that we have worked with. One of the possibilities is completing the paper-based cases in a paper-based environment and starting afresh in the new system. So not carrying the paper files into the system. The second possibility, as Khachatur has shown, now since we have OCR, it is very possible to carry the paper files into the system. So scanning them and uploading them, and then also using the new cases within the case management system. So there are two possibilities. Either they can be left in the paper format or they can be carried into the new system.
Thank you, Nysen, and thank you, Khachatur. This brings us to the end of our session on paperless court. I want to thank everyone for your time and attendance. We will publish the recording of the webinar in English and French on YouTube and send it to your emails. For the questions that we didn't answer, we will definitely get back to you individually. Once again, if you want to have more in-depth discussions and system demos, we will be happy to organize that as well. Feel free to reply to one of the emails you received from me. Look forward to staying in touch and hope to have you in our next webinars. Thank you and goodbye.